mooring buoys.
Okay. Well, that was where they were talking about whether to have a conditional use permit.
Correct.
I thought we dealt with that when we were there.
Is that number 9 on 7.5? What you're talking about?
7.5, well, 7.6 actually is where the shoreline environment regulations begin.
Talk about what happens within priority aquatic,
Uh-huh.
natural conservancy,
Mhm.
shoreline residential, high intensity.
Yeah, and whether or not the allowance in the aquatic and priority aquatic designations is dependent upon what designation is adjacent upland. Right now,
And what permit types?
and what permit.
SDP versus a conditional
So right now,
is the question of
Mhm.
issue.
Yeah, what we have here now, based on, this is the planning commission recommendation, is that there would be no CUP required for any mooring buoy. It would be an SDP only in all designations. What staff had recommended was to require a conditional use permit in either priority aquatic or aquatic when it's adjacent to the natural designation. And the tribal letter was requesting, I suppose might be considered more protective approach, which is conditional use permit for any mooring buoy going to go into priority aquatic, sort of regardless of what designation is next adjacent to it, and then also in conservancy and shoreline residential.
And then continue the discussion about a conditional use permit being administrative, a CA, a CD discretionary, or a full-blown CUP, hearing examiner. Because that's another issue we have with,
Right.
if you go conditional use permit, what type? Conditional administrative decision, conditional discretionary. The administrator determines whether it's a full-blown public hearing before the hearing examiner, or it's a CA, conditional administrative, or it's a full-blown CUP, type 3, hearing examiner, open record hearing, hearing examiner decision, which is our most sophisticated, complicated, expensive permit.
And let's see, this was, page 5 of the Point No Point Treaty Council letter. They were suggesting this. Yeah, there it is. I'm trying to think of what the goal is. It seemed like the goal was to make sure that they were notified, number one, and so they had a chance to have input, and that the cumulative impacts would then, because they in the state, and everybody was notified, there would be an opportunity to assess those, and comment on those. And according to our discussion the other day, you're saying even without a conditional use permit, letters are sent out to the tribes and DOE, and so they can use that information to track what's going on and comment even without doing a conditional use permit at all.
Right. But the criteria of the conditional use permit is where you get more weight for cumulative impacts, consistency with the comp plan, various, some of the other criteria.
Well, yeah, and the thing to know that a substantial development permit is a conditional use. But yes, the conditional use permit would add another batch of criteria that we would review that application for.
And those criteria would be what?
Yeah, actually, let's just go to that page.
Conditional use,
The conditional use
Is that
criteria, okay, yeah.
section way back?
Article
So it's
9.
page 9-8. And it is that the use is consistent with the policies of RCW 9058-020 and this program, that the proposed use will not interfere with normal public use of public shorelines, that the proposed use of the site and design of the project will be compatible with other permitted uses in the area, that the proposed use will not cause adverse effects to the shoreline environment in which it is located, and that the public interest suffers no substantial detrimental effect. And it goes on, you know, the cumulative impact and.
You know, Al, you just gave a sort of a three-level definition of conditional use permit, and which makes me wonder if we need to put in what level of conditional use permit is required when we say that something may be allowed with a conditional use permit. If
That's
that's
why
not,
Michelle's got the matrix and back to the table, because agreed, there's the CA, the CD, and the CUP.
Yeah, and you, in the use table at present, it's gonna tell you whether it's a CA or a CD, conditional administrative or conditional discretionary. In the use table, the notation is a P, meaning permitted, which most often will mean the SDP. Is that, let's see, how do we do the notation? And actually, this is a planning commission notation that currently stands mostly the same. I mean, the use of the term, I think, the use of the notations is the same.
Right, so the use table does prescribe whether, for everything that we've defined as a conditional use, whether it's discretionary or administrative. That was the intent of the use permit, of the use table. There's also a designation for uses that are permitted. We had a little bit of this discussion on Monday. Permitted in that case could mean a substantial development permit, or it could mean a statement of exemption, which is a type 1 permit through your permit process. So it could be either or, and it depends on whether it's defined as an exempt use or development in the Shoreline Management Act, or whether or not it meets the definition of development, which includes a fair market value threshold for the actual construction of whatever it is you're building.